Welcome to the Indian Gaming Association's The New Normal webcast. My name is Lisa Johnson, and I'm the conference manager for the Indian Gaming Trade Show and Convention. I'd like to share a few housekeeping tips before we get started. Everyone is muted by default except for our speakers. If you have any questions during the presentation, please type them into the chat box. Now, without further ado, I'd like to introduce Victor Rocha, conference chairman of the Indian Gaming Association.
Good morning, everyone. Welcome to the New Normal, your source for discussions on the gaming industry and key issues facing Native American tribes. I'm Victor Rocha, the conference chairman of the Indian Gaming Association. My co-host, Jason Giles, is out today due to a medical emergency. He asked me to tell everyone that he's okay and he expects to be back next week, which also coincides with the NCI Executive Committee Week. And he wanted me to tell you that that's going to be front and center at NCI prediction markets next week, too. Today, we're joined by my friend Daniel Wallach, one of the most closely watched legal analysts covering sports betting, gaming law, and the growing wave of lawsuits challenging prediction markets. Daniel, good morning. How are you doing, my friend?
I'm doing great, Victor. Thanks for having me back on. This is the second time, but it's also the second time that Jason hasn't been here. So I'm
I
wondering if he
see
has
that it's
does he
not
have the Dan Wallach
personal.
influenza?
He's saying that, you know what he said is he's had a bad knee,
Mhm.
and he said it blew up to the size of a softball. So then he got back from Barcelona.
Yeah,
And I think the prediction markets kneecapped him, and he's just not saying
yeah.
anything.
Those conferences can be hell on the joints. I know.
Listen, ICE is massive, man. It is one of the biggest shows in the world, and it is incredibly huge. And we're fortunate that we were actually right in the middle, which made it a lot more tolerable in
Yeah,
walking back and forth and stuff like that. But it's an incredible show.
yeah.
Daniel,
Comfortable.
let's jump. Yeah, go ahead. Let's
Yeah, I was gonna
jump
say
right into
comfortable
this.
footwear is the key. Comfortable
Oh
footwear is
my
the
God,
key.
it's sneaker culture. Thank God these young people brought sneaker culture into the gaming industry, man. Because we used to die with Italian leathers and stuff like that on those trade show floors. That stuff don't fly anymore. Listen, man. Anybody, if you're not following Daniel on social media, on Twitter especially, then what are you doing? You know what I mean? He brings. It's always been entertaining. Daniel, you are really quite amazing in how you keep on top of it. I think you help a lot of us in the industry. I know you do, as a matter of fact. So, we're starting to see the lawsuits pile up, man. What's triggered this wave of legal actions? What do you think is happening here?
Three things, right? The losing streak finally ended with the Maryland federal court ruling on August 1st. That was the first time that a federal district court denied Kalshi's motion for preliminary injunction, and quite frankly, called out Kalshi on its prior inconsistent judicial statements. It had taken the position in all these earlier cases involving the CFTC over election contracts by saying that the gaming category, which is the bad category, only includes sports betting, and Congress didn't want sports betting to be conducted on derivatives markets. That was the first court to call Kalshi to task on that, and so that was a key driver for triggering the avalanche of new lawsuits. Two, the involvement of the tribes as amici curiae, which began with the Third Circuit but made the difference in the Maryland federal court decision. That was number two. Number three, Nevada made the tactical decision to hire outside counsel. Mayor Brown, which is one of the top 50 law firms in the United States, and their lead counsel for Nevada is Nicole Saharsky, who's a veteran of 32 United States Supreme Court oral arguments. So they've gone from having their in-house attorneys poorly litigating the case to turning it over to one of the preeminent U.S. Supreme Court shops in the nation. And on a dime, the Nevada preliminary injunction, which went in favor of Kalshi, got dissolved within a matter of months, largely because of the participation of the tribal amici and the engagement of top tier outside counsel. So on Labor Day, there were only three states in litigation with Kalshi. Now there are 12. And I think it was all triggered by the tsunami of the Maryland ruling, aided and abetted by Nevada's outside counsel hiring and by the tribal involvement, beginning with Maryland.
It's been kind of funny to watch Kalshi's argument dissolve in the thin air at the very beginning about preemption and how they can't, geofence because it'll cause them all kinds of damage. And then you have Coinbase and Polymarket just rushing to do it, which is kind of undercuts everything they said, right?
Yeah, well, the geofencing argument that Kalshi is maintaining is falling under its own weight because now they're an $11 billion valued company. So
Right.
complaining about having to spend $10 million or so on geofencing, that's a very small fraction of its overall value as a company. But more importantly, companies like crypto.com and more recently, some of the online sports betting companies are entering the prediction markets and they're geofencing in
Right.
some weird, perverse way. You may not appreciate the significance of it, or maybe the tribes don't appreciate the boost that DraftKings and FanDuel joining the prediction markets actually gave to the state and tribal cases by showing that not only is geofencing not burdensome, but we can do it at the flip of a switch. And with FanDuel, DraftKings, Fanatics. I don't know if Fanatics is geofencing, but I know that DraftKings and FanDuel are based on what they're saying. And Crypto.com is excluding, they're geofencing Nevada. Robinhood is excluding patrons from Nevada. And now, more recently, Polymarket, in response to the TRO issued by a Nevada state court judge overnight, they began geofencing Nevada. So how burdensome can geofencing be? And I think that has become the major one, what turned initially into a strength of Kalsi's legal argument that this was so impossible, impractical, and burdensome is now their Achilles heel going forward in all these federal and state cases.
Yeah, it was that was very noticeable even for a layman like me, to watch and to see it dissolve. But you know what? A lot of this stuff is just being stress tested by the courts, everything they say, and before we went, we're going to be talking about Michael Selig too. But you notice in Nevada, they use Selig's comments about, he's going to defend that. And how well did that go with the judge?
Well, this is Kalsi's typical tactic of overselling something. I mean, they've even argued in their court papers that the Wire Act allows betting to occur across state lines. And every gaming lawyer, every tribal gaming lawyer, everybody involved in the gaming industry knows that the Wire Act does not provide a safe harbor for out-of-state sports bets. Only information relating to the placing of sports bets, like odds, lines, risk management tools. So they have had a track record. This is a great firm, top tier firm like Milbank Tweed, and it just goes to show you that no matter how big or prestigious the firm is, they'll lie if they can get away with it. And what they did with Michael Selig's comments, which were made at a joint CFTC SEC roundtable, which he prefaced his own remarks by saying, "I'm saying these in my own personal capacity, and these don't necessarily reflect the views of the commission." What Kalsi did afterwards is take those comments and try to file it as supplemental authority in every single one of these pending lawsuits in the Third Circuit, in the Fourth Circuit, in the Ninth Circuit, in the New York and in Tennessee and Southern District or Middle District of Ohio federal district court cases. They've attempted to equate his off the cuff, well, they're not off the cuff comments. They represent his personal views, but they have not officially represented the views of the CFTC. And Kalsi is saying this is the new position of the
Right.
CFTC when the CFTC had every ample opportunity to jump into these court battles and file an amicus curiae brief like the tribes did, like the AGA did, like the state attorney generals did. And the CFTC stood down, didn't file anything. And now at the last minute, Kalsi is trying a backdoor belated amicus curiae brief, which misrepresents the official nature of Chairman Selig's comments, which were made in his personal capacity and have not yet been implemented into an official act of the CFTC.
Well, what are the chances that the Kalshi influencers are writing these legal briefs? Because it sure seems like it, doesn't it?
Well, the legal briefs, to Kalshi's credit, to the credit of all the DCMs, they're using creme de la creme law firms.
Right.
Kalshi is represented by Milbank. You have Ted Olson's old law firm. Ted Olson,
Yeah.
who recently passed away, is the godfather of legal sports betting in the United States. He made it all possible. Well, his law firm is now representing Robinhood in these class action lawsuits pending in federal court that are between disgruntled, traders and Kalshi. But all of the top law firms, Cravath, Sullivan and Cromwell, uh, Milbank, top tier law firms are all representing the prediction markets. So they have not just influences on their side, they have top tier white shoe law firms, Silicon Valley, investment firms, Wall Street firms, the White House, the CFTC. I mean, I hate to call it David against Goliath, but sort of the roles are reversed here. You're going up against the administration and some of the pillars of the Wall Street and legal community. So this is an incredibly challenging battle for the states and the tribes, who, by contrast, at least with respect to the states. They're not using outside counsel except for Nevada and Ohio, and they're not as well oiled a machine working collectively as the prediction markets are, which have a ground game in the courts and are now lobbying Congress through their new trade association. By contrast, the states are acting individually, not collectively. Tribes are participating only indirectly by filing amicus curiae briefs, and they're in a holding pattern. The tribes are in a holding pattern until the Ninth Circuit, which is hearing oral argument in April, reverses that insanely wrong San Francisco federal court ruling, which held that IGRA does not apply to internet-related gaming activity within Indian lands. Once that case or that decision gets reversed by the Ninth Circuit, and I'm predicting right here that it is, then that might open up the floodgates for more tribal-backed lawsuits against companies like Kalshi.
Yeah, well, you know what? We will be talking about these lawsuits at our show in March and April. And Daniel, as I just said, we're inviting you to come on down too. We'd love to hear from you and talk more about this.
I accept.
So, yeah, well, it's going to be great. San Diego, the end of the winter, everybody loves to come down to San Diego, and it's really a
Thank you.
beautiful city.
Thank
So,
you. I love the Gaslamp Quarter, and it's one of the most dog-friendly cities in the United States. What's there not to love about San Diego?
yeah, we love it too. So, this seems like it's starting to become against, the CFTC against state laws, right? I mean,
Well,
that's what it's coming down to.
it always has been. The lawsuits that were initiated by Kalshi from day one always pitted the federal law as preempting state
Right.
sports gambling laws. Kalshi made a very smart strategic move or the states made a strategic blunder of sending cease and desist letters to Kalshi, which in turn gave Kalshi the opening to run into federal court, file a lawsuit in federal court, and narrowly frame the issue around the issue of the CFTC's jurisdiction, exclusive jurisdiction, rather than have the underlying legality of the contracts placed in issue before the court. By contrast, you're seeing states like Massachusetts and now more recently the Nevada Gaming Control Board go directly into state court, sue the companies directly in a civil enforcement action, placing the legality of the sports event contracts under state law directly at issue. But when the states began sending cease and desist letters to the companies were able to successfully avoid these state civil enforcement actions by tying the issue up in this elongated battle over whether the CFTC has exclusive jurisdiction. None of these federal courts are addressing the $64,000 question of whether they involve gambling. They're just
Right.
addressing the issue of who gets to decide that question.
Well, and it seemed like in the very beginning, that's what it was about. It's like, this is gambling. These event contracts are gambling. And it feels like we were walking into a trap. They were like saying, come on in. This is the fight we want to have. But once it started changing about what the intent of Congress meant when they did this, you started seeing them scream and whine and complain. It's like I said, that's definitely a pain point.
Yeah.
Talk about that a little more, man, because I know you mentioned it on social media too.
Yeah, the game changer on this count was the Maryland federal court decision. Some of the earlier cases, in particular the New Jersey ruling that went in favor of Kalshi, the judge, in that case, Judge Keel, wore blinders and focused only on the narrow issue of whether event contracts tied to the outcomes of sporting events met the CEA, Commodity Exchange Act, definition of a swap. Looked at it with blinders very narrowly, and the definition of a swap under the federal statute is basically a contract which depends on the occurrence or non-occurrence of an event. And in applying that definition, Judge Keel concluded that sporting events, because they have potential economic, financial, and commercial consequences vis-a-vis advertising revenue, television ratings, team valuations, because there are economic consequences associated with who wins or loses a particular sporting event. In Judge Keel's view in New Jersey, that rose to the level of being grouped within the broad definition of a swap. And since it was a swap, subject to the exclusive jurisdiction of the Commodity Futures Trading Commission, that meant that the state governments would not be able to interfere or regulate any on-exchange trading involving sporting event swaps. So that narrow ruling basically locked out state gaming regulators, but it was the only decision in the country, and to date, it's the only decision in the country that has resulted in a favorable ruling for Kalshi. Every other court, Maryland, Massachusetts, Nevada, has sided with the state governments. In fact, the Nevada decision of October dissolving the preliminary injunction unwound the first win that Kalshi had against the state. And in fact, the New Jersey ruling relied heavily on the Nevada federal court ruling, which has since been reversed by Judge Gordon in Nevada. So when the dust settles, we're now looking at an avalanche of state victories piling one on top of another, and only one case back in New Jersey, which is on appeal now to the Third Circuit. There's only one court in the country that has decided the matter initially in favor of Kalshi. And the changing of the guard here occurred when the Maryland federal court broadened the analysis beyond whether or not these contracts are swaps by focusing on the overarching issue of congressional intent. You know, the question isn't whether sports contracts are swaps in the Maryland judge's view, and now the Massachusetts and Nevada courts' views. The question is whether Congress, when it enacted the Dodd-Frank Act in 2010 to give the CFTC exclusive jurisdiction over swaps, whether the clear and manifest intent of that law was to displace state sports gambling laws. And under that type of an analysis, Kalshi is going to lose 99 out of 99 times. So by looking at the overarching issue of what Congress intended in 2010, you consider not only the plain language of the Commodity Exchange Act and Dodd-Frank, but you look at the legislative history and the fact, the undeniable fact, the dispositive fact that in 2010, Congress had several laws in place, namely the Wire Act and PASPA, which specifically prohibited interstate sports gambling. The Wire Act definitely prohibited interstate sports gambling. PASPA prohibited the states from authorizing sports gambling. So those two statutes, along with IGRA, along with a number of other federal statutes affecting sports gambling, reflected Congress's policy. At least let's exclude it. It reflected Congress's policy of disfavoring sports gambling. So it really flies in the face of all logic and defies logic to think that at the time Congress expressly prohibited sports betting across state lines in 2010, that somehow it created a secret side door to allow the CFTC to become the nation's sports betting regulator without using clear and explicit language in making that intent clear. So that's the uphill battle that Kalshi faces when it has to litigate against the backdrop of trying to determine what Congress's intent was in 2010. They have an easier case if the court is only focusing on the narrow definition of what is and what is not a swap. But when you look at it at a higher level and consider the factors, the legal circumstances in effect in 2010, the statements made by the lawmakers in the congressional record, which made pretty crystal clear to me that Congress did not want gambling to be conducted on the derivatives markets. And the specific example that was cited by the Senate committee chairwoman, Blanche Lincoln, whose committee wrote the Dodd-Frank Act, her comments on the record was that sporting events such as the Super Bowl, the Kentucky Derby, and the Masters Golf Tournament do not have any real commercial value and should not be the kinds of contracts that are traded on CFTC regulated exchanges. The mistake that Congress made, however, was by not making that an explicit ban against gaming contracts, but only giving the CFTC the authority to prohibit those contracts as being contrary to the public interest, because at the time in 2010, Congress was not going to hypothesize and come up with all these examples and illustrations of different types of gaming. It was going to defer to the expertise of the CFTC to decide which types of contracts are gaming. But the clear intent of the 2010 special rule that was enacted in Dodd-Frank was to create these 6 categories: war, assassination, terrorism, gaming, activity that is illegal under state or federal law, and created these 5, categories that should not give rise to event contracts, but offloaded or delegated to the CFT to the responsibility for determining whether a particular contract that came up in the future was or was not gaming. But the clear intent of Congress was to equate gaming with sports gambling based on the legislative history of the statute And reading that alongside of the Wire Act and PASPA prohibitive language that spoke directly and forcefully to sports betting. And in fact, the Third Circuit in the Christie versus NCAA case a number of years back viewed or explicitly stated that the Wire Act and PASPA evidence Congress's strong policy of disfavoring sports gambling. So that's the sort of the high hurdle that Kalshi now has to clear under a congressional intent analysis. And because gambling is a field that's traditionally regulated by states, the U.S. Supreme Court has dictated that courts are to apply a strong presumption of against preemption to any area that is traditionally regulated by state governments. And of course, gambling is at the core of the state's historic police powers. So to overcome that strong presumption against preemption, Kalshi needs to be able to show a clear and manifest intent by Congress to displace sports gambling laws. And when you view everything through the 2010 lens, that just doesn't seem plausible.
Yeah, it seems like everybody's screwing up Kalshi's plans, you know what I mean? Because they were screaming about preemption in the beginning. It was like preemption over the state laws. But I think you see that Coinbase and Polymarket are acquiescing so fast that everything that they've
Not
been
Coinbase.
screaming.
Coinbase just got sued 2 days ago,
Right,
and they're faced with a motion for temporary restraining order and preliminary injunction. They may be in that situation a week from now, but for now, Polymarket is the company that got TRO'd in Nevada
right,
State Court, and within a day,
right.
they bailed out of Nevada.
Well, and then what they're talking about geofencing. You know what I mean? They're the ones that are undercutting the arguments by Kalshi, which is hysterical. But most of their arguments have been, I think everybody in the industry can agree that it's just been preposterous. And the fact that they lie all the time just goes with what we're seeing here. You
Yeah,
know what I mean?
not
Which
all the
is,
time. Oh, not all the
well,
time, but I think you lie once, you lose
yes,
credibility.
well, just when their eyes are open,
Yeah.
just when their eyes are open.
I mean,
You're right.
I don't want to disparage the Milbank firm. I mean, when I went to the oral argument in Philadelphia, there were like five of them. They're all like experienced Supreme Court and appellate advocates. They're like the Star Chamber. And New Jersey brought in like someone from the Solicitor General's office. It was a mismatch, and the mismatches led to an early advantage for Kalshi because when they got the preliminary injunction against Nevada. Nevada at that time was represented by the state attorney general's office, and they didn't write a very effective brief.
Right,
Their opposition brief to the PI motion didn't even raise the Wire Act, didn't even raise IGRA.
right,
Any early victories by Kalshi, I think, were largely occasioned by the disparity in the talent of legal counsel. But those early victories have now created a long runway for sports
right,
event contracts, which are going to exist in the vast
right,
majority of states, at least in my opinion, until the Supreme Court ultimately decides the question. If they decide the question in 2028, had Nevada hired Mayor Brown and Nicole Saharsky on day one, and that preliminary injunction gets denied, New Jersey may have denied the same injunction, and then we're not talking about sports event contracts. So even though the pendulum has swung and the tide has turned and the states have won the last six rulings, those early victories, preliminary victories by Kalshi have all but ensured the elasticity of sports prediction markets, at least through the end of calendar 2027, until the issue is decided by the courts or Congress. There's nothing any state legislature can do about this. There's nothing the CFTC can do. They can place their thumb on the scale, but ultimately, this is an issue to be decided by the courts. And if the courts rule that federal laws do not preempt state sports gambling laws, it's game over unless Congress intervenes and amends the Commodity Exchange Act or passes a federal sports gambling regime that provides some legal cover for sports prediction markets. So right now, the game is in the courts, but ultimately, it may be decided by Congress.
It feels like they're moving really, really fast, so people can't focus on what's really important. I mean, well, let's talk about Michael Selig. Okay, so Michael Selig gave an interview the other day, or he was on a panel the other day, and he basically came out, and that's where Kalshi basically said, "Hey, listen, these are the new bosses in town," and he said everything they wanted to hear, didn't he?
Yeah, I mean, we knew going in that that's what he was going to say. It's so typical in these Senate confirmation hearings. you know that the candidate for confirmation is a zealot in favor of sports gambling. He was a partner to Wilkie Farr and Gallagher, a major law firm, who he co-authored a letter urging the legality of sports event contracts before he ever became CFTC commissioner. So this is like the operator becoming the regulator. And when he was before the Senate, he took a very like neutral view, like, hey, it's the question of what is or what is not gaming. It has vexed federal courts for years. Who am I to decide whether gaming is coextensive with sports betting? Well, within the period of 90 days, he decided fairly conclusively that the gaming classification within the special rule statutory provision did not encompass sports betting, and that he would do everything to place his thumb on the scale to ensure the viability of sports event contracts under the CFTC's regulatory sphere. So the CFTC is going to go from a position of being inactive and not pushing back against any of these self-certifications made by companies like Kalshi. The CFTC regulations allow companies to trade or list contracts immediately upon filing a notice of self-certification of a particular contract. And if the CFTC does not intervene, those contracts can go live the next day. So to use an extreme example, if one of the platforms wanted to self-certify a casino style event contract and the CFTC did not object to it, that could go live a day from now. And so the
And it will.
CFTC is going to
And
go from
I
not
think
doing anything about it to now passing explicit rules and regulations that provide the agency's formal imprimatur or approval of sports event contracts, along with probably a regulatory framework surrounding it that would satisfy some of the sports league concerns about integrity monitoring and might include some baseline know your customer protocols and responsible gambling guidelines. So the CFTC under Michael Selig's watch is not only going to champion sports event contracts, but they're going to pass rules allowing it.
Right. Right. And that's what he said. And I guess that's what we expected. Do you think Brian Quintenz is like kicking himself in the butt saying, gosh, I should have said that.
He,
That's
no, he
what
was
I
going to do
should.
the same thing. He's a
Yeah.
board member of Kalshi.
Yeah. Yeah.
Owns
Yeah.
stock. He owns stock in Kalshi. He was going to do everything.
He was going to give it up if he got nominated too. And he didn't give up a penny. You know what I mean? We were watching,
Yeah,
you
but
know?
there are a number of other influential stockholders besides Brian Quintenz. You have Donald Trump Jr.
Right.
He's an advisor to nine different CFTC regulated platforms. Was it Polymarket, Kalshi? Do you think he's getting lunch money or expense reimbursement? No, he's getting stock. So regardless of who's the figurehead at the CFTC, they're going to be doing the bidding of the Trump administration and be pro prediction market, pro crypto, pro sports
Right.
event contracts, because what's good for Kalshi, what's good for Polymarket is definitely good for those in power. And namely, you're talking about the stock holdings of the Trump family, never been reported. I'm just speculating that if Donald Trump Jr. is a strategic advisor for nine different platforms, he probably has some skin in the game. And they've given him
Yeah.
grants, share-based compensation, or stock options. So what happens with sports wagering, sports event contracts being the vast bulk of the valuation of these companies? So with sports wagering, the upside is in the billions. Without sports wagering, the valuation of these companies goes
Right.
to a very low level. So no matter who was appointed to be CFTC chairman, this was always going to be a pro prediction markets agency,
But
at
then
least for now.
what's wild is like, you talk about like the war and the five pillars or whatever it is, but yet, the whole thing with Maduro, okay? You know what I mean? So it wasn't a war, it was a snatch and grab. It wasn't an invasion. It was, but they're betting on conflict and war and stuff like this, which seems should have been, but where is the enforcement? Who's going to do
And
the
ironically,
enforcement?
those kinds of contracts are barred by a CFTC regulation. CFTC regulation 40.11A1. Several people in the audience may know it. Well, if Joe Webster's listening, he certainly knows about it. That regulation expressly bars the listing or trading or clearing of event contracts involving, referencing, or relating to war.
Right.
terrorism,
Right.
gaming, assassination. Those contracts should have been per se barred, but it highlights a bigger problem with some of the sketchier prediction market platforms like Polymarket and Kalshi. I'm not talking about the Chicago Mercantile Exchange or DraftKings or FanDuel. I'm talking about the disruptors who are listing event contracts around stuff that people will say or around events that have already occurred. Wasn't there like the mention markets? This is an incubator beyond anything else for inside information. Some people are going to have it, most people won't. The public is at a disadvantage. The institutional investors are at a major advantage. And it really creates an unlevel playing field that is more deleterious to the consumer than state regulated sports betting. And eventually, the courts are going to be wise to this. And as courts begin to determine whether or not to grant a preliminary injunction in favor of Kalshi or one of these other companies, or even in favor of the state, one of the core questions on every preliminary injunction motion is what's in the public interest. And
Right.
as these prediction market platforms begin to push the envelope, props, parlays, mention markets, I think it swings the public interest analysis, tilts it much more heavily in favor of the states, and makes it a more of an uphill battle for Kalshi to win these federal court, contests. If they weren't doing themselves if they weren't doing themselves a disfavor by taking different positions in earlier federal court battles, by claiming they can't geofence, on top of that, their aggressive expansion into markets that go way beyond outcomes of sporting events really threaten to topple and undermine their legal arguments on a going forward basis. Had they kept everything to just
Listen,
outcomes of sporting
they're
events, they may have had a clearer, cleaner path to victory, but I still think in the end, even that would have been an uphill battle. But now there's just recklessness, no caution, and their marketing and their actual operations are severely undercutting the integrity of their legal arguments. And that's
right.
beginning to make a
Right.
difference in the Nevada federal court decision, the Massachusetts Superior Court decision, both of which highlighted the expansion into props and parlays as a major factor as to why it wouldn't be in the public interest, and ruling ultimately against Kalshi in those cases. They had an early victory based on a state of affairs which existed in April and May, which was very limited. And on the heels of those early victories, they couldn't help themselves. And
Right.
they went so far, so aggressive, and their marketing and their operations have undercut their legal arguments in so many different spheres.
It's been wild to see Dustin Goker being quoted in some of these because he's catching them all the time, and it's like he's just, I mean, every single day he's catching another lie and another one. It's just really quite amusing that that's what these guys do. They just lie about everything. I'm talking about Kalshi and the point I want to make was that, Sarah Slane, who works with them, knows better. They're not listening to her. She knows about geofence, she knows all about that stuff. She worked in that. So for the fact that they
Not
didn't
only
listen to,
that, not only that, let's stay on Sarah Slane for a moment.
yeah,
When she was with the AGA, she testified before Congress. She submitted written testimony to state legislative bodies, all of which, all of her testimony said that the federal government should stay out of the regulation of sports gaming, and that the states and the tribes are doing it very effectively, and that there's no role for federal inclusion in the regulation of sports betting. She said that chapter and verse. I have the transcripts. They're all a matter of public record. And she changed her tune the moment she bailed ship, changed sides, and betrayed the gambling industry by it's okay to better oneself professionally and work for competition. All is fair in that. But she's pretending everything she said previously did not exist, and she's done a complete 180. And then on top of that, she's disparaging state gaming regulators and tribal gaming regulators as nothing more than 50 slot machine regulators, as if they're just a bunch of country bumpkins like Mr. Haney from Green Acres who can't figure out the intricacies of digital gaming. And not only is she saying that's become a talking point of Kalshi as well. I was at a futures and derivatives conference in Naples, Florida this past weekend, and I was on the panel. And my inclusion on the panel so unnerved Kalshi that they insisted on having their general counsel being in the audience, given an opportunity for equal time to respond to
Yeah,
anything that's said on the conference. And during his so-called equal time, he again made the Slane-like reference to 50 separate state slot machine regulators,
right,
Mr. Haney,
right.
Mr. Haney, Mr. Haney, when there's no question that state gambling regulators and tribal gaming regulators are far more sophisticated in addressing issues of know your customer, consumer protection, integrity related issues. The states and the tribes are light years ahead of where the CFTC is, and the CFTC does not have any specific regulations or rules governing sports integrity, problem gambling, none of the protocols that exist in the state or tribal regimes. So it really bothers me when, if you got a good legal argument, make it.
Right.
All's fair, in the courts, give it your best shot, but you don't have to lie. You don't have to misrepresent that the Wire Act allows cross-border sports betting. You don't have to lie that gaming activity on Indian lands doesn't include the internet. You don't have to lie that the states are ill-equipped and ill-suited to regulate gambling, and only the federal government can do that when Kalshi's own corporate representative Sarah Slane said on the record under oath in Congress, 10 years ago, even sooner than that, that the states and the tribes have it all under control and that the federal government should not be poking its nose in the realm of sports wagering. I mean, everybody's got some collective amnesia here. I mean, I saw the testimony, and that's as of record. So if you want to win, give it your best shot, make your federal preemption argument, but you don't have to drag tribes and states and diminish or disparage what the important work that they do, because they're doing it much more effectively than the CFTC is currently doing it.
Well, listen, it's all part of this mindset of this new generation of fintech, bros and girls, just they just this disregard because we didn't even talk about state taxation. We didn't even talk about that. But one of the things that really gets my goat as we're on here, which is they're dealing with the CFTC and Kalshi, and I said this on public media, insider trading is a feature, not a bug. If and they're starting to promote that. And that goes against everything that I know about the CFTC, which is this much, by the way, I think, as we all know. You know what I mean? But can you elaborate more on that for us, Daniel?
Yeah, I mean the CFTC's sphere of expertise on the issue of integrity monitoring relates to price manipulation. They don't have law enforcement personnel that are investigating match anomalies or wagering anomalies. That's not They're ill-suited to conduct that. Yeah, in the future, Michael Seelig may want to promulgate rules which requires the CFTC to engage in that kind of activity, but they don't do anything currently that regulates a gambling specific product. Their expertise is in commodities and safeguarding against price manipulation. What these companies are doing, though, like Kalshi and Polymarket and crypto, they're probably doing they're engaging their own experts to do that kind of work, but without clear guidelines or rules or accountability or consequences. It's going to vary operator by operator, and you cannot have a gambling framework that is entirely subject or mostly subject to self-regulation at least on the important stuff, the risk factors of match fixing and inside information. Inside information is a feature, not a bug. And I'm not talking about all the platforms. I'm talking about some of these events and some of the aggressive, just
Maduro, 900K.
shameless type of event contracts that Polymarket and Kalshi are offering. And it just boggles the mind that this hasn't become a flashpoint in some of these federal or state court cases. But I think that's eventually going to happen because it is ripe for a scandal. And one of the reasons why the NBA and Major League Baseball are getting so much attention with these recent indictments is because it showcases how legal sports betting, working hand in hand with state regulators, tribal regulators, and integrity monitoring firms, are the best detection tool. And they're catching this stuff. They're catching this stuff. Under the current CFTC regulated regime, there is a huge regulatory gap as well as vulnerabilities that exist all over the place, and we haven't even gotten to it's going to get worse in the absence of any specific regulatory framework.
I mean, at one time they were talking about betting on Little League games. You know what I mean? They were talking about, Pop Warner or something like that too. I mean, it's just ridiculous the amount of just decrepitness, you know what I mean,
Yeah.
in society and what they bring, you know what I mean? And there is no real true value here. This is not, one of the questions is that I had is that he talked about price discovery and information aggregation. I'm talking about Selig, you know what I mean? And this is not that, you
Yeah,
know?
price discovery on whether Daniel Jones throws for 175 yards in a game featuring the Indianapolis Colts. And the more recent event contract that I saw listed the other day from the Winklevoss twins, they own a company
Oh
called
boy.
Gemini Trust.
Yeah.
They self-certified an event contract, which I would loosely call time interval prop bets, which seek to base an event contract around how many points two teams will collectively or jointly score or record within a given period of time, like a quarter or a period. Where are the macroeconomic consequences associated with that? Listen, I get the base case for the Super Bowl, the Masters, and the golf tournament, but this arms race between all these different companies has led to some of the more aggressive ones pushing the envelope well beyond what was ever intended by Congress for a swap, right? And what's first started out as that the archetypal example offered by Kalshi in its federal court papers against the CFTC when they were litigating over politics and political event contracts, the illustrations that Kalshi cited were the event contract, an example of an event contract would be hotel groups hedging, buying event contracts tied to whether or not a hurricane would
Right.
occur because a
Right.
hurricane could wipe out the tourism season of hotels and hospitality establishments on the Gulf Coast of Mississippi. That's hedging, right? Hedging doesn't entail whether a player will exceed a certain statistical benchmark in a meaningless regular season game. So at some point, Congress, not Con I'm sorry, the courts are going to have to settle this because the agency, the CFTC, has shown that it will not properly police this. The companies acting out of self-interest will not police this. State legislatures are powerless to police this. And I want to speak very briefly about efforts to prohibit or regulate prediction markets under state statutes. There have been bills introduced in New York, I believe Hawaii, Tennessee, that would seek to rein in sports prediction markets under state law. But I think those efforts would be time wasters, at least for now, because the battle that's forming in the state and the federal courts is whether existing state laws are preempted by the Federal Commodity Exchange Act. If a state passes a new state law specific to prediction markets, all that does is make it another existing state law that will get jammed up in federal court litigation over whether the Commodity Exchange Act preempts state existing gambling laws. So I don't think there's any point. I wouldn't exactly call it a fool's errand, but it has no place in time, at least right now, because the courts will ultimately need the courts have to settle this issue, not the agency, not state legislatures. It's either going to come down to the courts and or Congress. Nothing else is going to have an impact. And I think the courts are beginning to push back and recognize the fallaciousness of Kalshi's federal preemption argument. And the last six rulings, Maryland, three times in Nevada, two times in Massachusetts. I think the last six federal court rulings have rejected a prediction market federal preemption argument. So now there's a trend line forming where the later cases, particularly the Polymarket decision out of Nevada last week, relied on the Massachusetts and Maryland rulings. And the more of these state favored rulings that get issued, the more precedent that's created, and the greater the likelihood is that those rulings are going to influence downstream rulings. And now we're waiting for court decisions in New York federal court, Ohio federal court, Tennessee federal court, and Connecticut federal court. And each time a state wins an earlier case, it increases the likelihood that they're going to prevail in Connecticut, Tennessee, New York, and Ohio. And I guess the question remains, Are we ever going to have a circuit split, or is this going to be a runaway train that favors the states? And until we get our first federal appeals court decision, and I think the Third Circuit will be the next one, it's difficult to handicap whether or not the Supreme Court will take the case. But if this current trend of state victories continues, there may not be much of a debate.
Well, you listen, I think it's very important that we make the proper court cases. You know, and I think this is a fight against states' rights. This is a fight against gambling. And the big question here, Daniel, is what is prediction markets without sports betting? Without sports betting, they are but you see them in the UK. You walk into William Hill and you bet on the BAFTAs or something like that. So they're not that exciting or that sexy without sports betting or gambling. And now, big question to me is, with Michael Selig saying, okay, we're going to promulgate some of these rules and stuff like that. How is that going to affect later court cases, or is this just trying to change on the dime and trying to affect court cases?
I don't think it's window dressing. I think the CFTC is going to weigh into these court battles by filing amicus curiae briefs. It hasn't filed anything before, and it was the CFTC's absence from all these prior federal court proceedings, I think, was pretty noticeable to the courts because these cases focus squarely on whether the CFTC had exclusive jurisdiction over sports contracts. Well, if the CFTC is not weighing in, I think that does indicate to the court that the CFTC doesn't have a particularly strong position one way or the other. Otherwise, it would have weighed in, and it may have psychologically undercut Kalshi's legal arguments. So now, if the CFTC jumps into these future cases, by the way, the ship has sailed in the Ninth Circuit, the Fourth Circuit, and the Third Circuit. Those three court or appeals cases have already been fully briefed and have either been argued or are set for argument. And by the way, a couple of future dates to notice. Today, the Fourth Circuit announced that the oral argument in Kalshi versus Maryland will take place in the week of May 5th through May 8th. The Ninth Circuit appeal, which has outsized seismic repercussions to California, there are four appeals in the Ninth Circuit. Appeals filed by Kalshi, Robinhood, and Crypto.com. Those three appeals are going to be consolidated for oral argument in April. And you also have separately the three Northern California tribes that are appealing that San Francisco federal court decision, which found that Kalshi trades on Indian lands aren't gaming activity. Well, that decision is being appealed to the Ninth Circuit, and that's still in the process of being fully briefed. Kalshi's answer brief is due on March 9th. The California tribes respond on March 30th, and that case will be separately orally argued probably in May or afterwards. And that's an important case to watch because the outcome of the tribal appeal will either resurrect IGRA as a federal law that encompasses internet wagering, or it will slam the door shut, at least for now, on the ability of tribes to sue Kalshi directly in federal court. That is a vitally important case for Native American tribes because Judge Corley in San Francisco found that if a Kalshi sports event trade is made on tribal lands, well, that's not covered by IGRA. IGRA only covers land-based gaming or within tribal lands, or even internet gambling only within tribal lands. The moment it crosses into state territory, it's covered by the Unlawful Internet Gambling Enforcement Act, and that statute has an exclusion or an exception for contracts traded on DCMs regulated by the CFTC. So the tribes have to get out and prevail on this Ninth Circuit appeal, which would restore IGRA's vitality as covering internet wagering that begins on tribal lands, even if it is ultimately received outside of tribal lands. And that is a critical decision. And it was a nonsensical distinction that Judge Corley made that simply because a wager placed on Indian lands crosses over into state lands, that doesn't change the fact that it's gaming activity on Indian lands. A U.S. Supreme Court decision, Bay Mills versus Michigan, recognized that the gaming activity takes place where the gambling occurs. Now, it doesn't foreclose gambling activity on Indian lands also occurring off reservation because, as you know, the Seminole tribe in the state of Florida agreed to an allocation of jurisdiction that recognized that internet or any wagering that was initiated on tribal lands is governed by IGRA. Outside of tribal lands, it's governed by state law. But the gaming activity is always going to be, at least in part, where the bet is initiated. And if the bet is initiated on tribal lands, regardless of whether it's with a ticket writer in a booth or over the internet, that's gaming activity and therefore is governed by IGRA. And under IGRA, gaming activity must be handled or governed or can only be done pursuant to a state tribal compact. And the tribes are given the right under federal law to enforce their exclusive right to gaming on their own lands. That is a critically important case that got away from the tribes in San Francisco, probably because Joe Webster wasn't litigating it, but is crucial that that decision be reversed by the Ninth Circuit. And to highlight how important this upcoming tribal oral argument is, the American Gaming Association, 30 states, led by State Attorney General of California, Rob Bonta, and let's see, the AGA, the states, and the National Tribal Amici, which are a coalition of Native American tribes across the country, which include Pechanga, Seminole Tribe, Mashantucket, Mohegan. They all filed amicus curiae briefs in support of those three Northern California tribes. In the lower court case, there was no amicus curiae brief filed. Those organizations didn't intervene and file briefs to help the California tribes in lower court case, but they're now doing it in the Ninth Circuit appeal, which obviously underscores the importance of the Ninth Circuit decision, not only on the federal preemption aspect in which Kalshi is an appellant, but also with respect to the tribes. The fact that all these groups are now weighing into the tribal case, with Rob Bonta being the lead signatory on the state's amicus brief, highlights or underscores the importance of that imminent decision.
I agree. Go, Rob. I think one of the important details, anyone who watched that court, I think she had a firm understanding of a lot of the issues on geofencing and stuff, and yet she gave that obviously wrong decision. So, we're looking forward to getting it into Supreme Court. Go ahead.
Yeah, I mean, she said that the first mistake right off the bat is Judge Corley viewed UEJA as a statute which regulates, internet gambling. UEJA doesn't regulate gambling. It simply provides an enforcement tool to prosecute crimes relating to the financing of illegal internet gambling transactions. It does not purport to legalize or prohibit any form of internet gambling. So she, in my view, and in certainly the tribes, the AGAs, and the state attorney general's views, she misread the statute. And I think it is I think there's a very good chance that the Ninth Circuit will reverse her ruling. But if the Ninth Circuit Appeals Court recognizes that the gaming activity occurs on Indian lands, whether it's placed on air or on land, that will give tribes across the country a potential point of entry to sue Kalshi directly in courts all over the country. If the Ninth Circuit affirms and leaves intact that San Francisco federal court decision, which held that UEJA supplants IGRA, that will basically relegate the tribes for the time being to participating only as amicus curiae in federal court cases around the country. So it's a critically important ruling that could impact tribes nationwide and also have major repercussions in California, because if the Ninth Circuit agrees with the Nevada federal court's decision that there's no federal preemption of state gambling laws, that could potentially impact market access to California on a going forward basis. Because if the Nevada victory is upheld by the Ninth Circuit, which includes California, Arizona, Washington State, Oregon, I forget the other states, Idaho and New Mexico, maybe not New Mexico, that could open the door to future state enforcement. For example, if the Ninth Circuit says that the Commodity Exchange Act does not supplant state gambling laws, well, what's to stop Rob Bonta from filing a civil enforcement action? He's already signed his name to an amicus curiae brief, which argues that there's no federal preemption. So if that brief contributes to the victory for Nevada, and the Ninth Circuit, which includes all of California, does not recognize federal laws preempting state sports gambling laws, that provides a point of entry for the state
Right.
attorney generals in California, Arizona, et cetera, to start initiating legal proceedings against Kalshi.
Yeah, it's an obvious violation of the state constitution. Now, I don't have any insider information, but I just knowing California like I do, that Attorney General Bonta is definitely looking at all options and he will take appropriate action because
Yeah.
he's just a badass. You know what I
Yeah.
mean? Okay, when he decides to run for governor, I think we'll all be there for him. I think he's doing a phenomenal job in defending California's sovereign rights. And when it all boils down to that's what it is. Daniel, there's a couple questions. We don't have much longer, but Rick Ray had an interesting question. One of the things that we talk about, they talk about, swaps and stuff at CFTC, but yet nobody's talking about these are house bank games, basically like gambling. They're all backed by someone. It isn't the market dictating. They have to have people back there providing liquidity for this thing to work. If that's right. Is that correct?
Yeah, yeah. First of all, that is exactly true, and that's beginning to seep into the federal court cases. The Nevada decision by Judge Gordon, in opening the door to dissolving the preliminary injunction, he pointed to changed circumstances, one of which was the props and parlays, but he also highlighted the existence of market makers such as Susquehanna International Group and the role that the market makers play in creating liquidity. And it's not just the liquidity there, it becomes like house banked. If you're gambling not against another patron, but your counterparty is Kalshi trading,
Right.
that's against the house.
Yeah.
And unfortunately, that's a narrative that did not begin to take root until some of the more recent complaints and decisions. But this is the story, and the narrative keeps getting, broader. And I think the federal courts have been late in recognizing some of these arguments, but better late than never. And if the most recent decision out of Nevada is any indication, I think the market makers are going to play an important role, or at least a partial role, in maybe tilting the decisions a little bit more heavily in favor of the states. And I can tell you that whether or not there's a market maker, the fact that it's an exchange and it's peer-to-peer does not preclude its characterization as gambling. Take a company like Sport Trade. Today, there was a
Right.
discussion in Sportico that after months of deliberation, Sport Trade
Sport trade, Alex Kane.
filed, Alex Kane filed an application with the CFTC to become a registered exchange. But it is also licensed as a sports wagering exchange in 5 different states. I
Oh,
think
he's gonna
Colorado,
settle it.
New
Yeah.
Jersey. So exchange-based wagering doesn't mean it's not gambling, does not mean it's not sports betting, because a number of states include exchange wagering within their broad compass of what constitutes a sports pool or sports wagering. And take horse race wagering, pari-mutuel wagering. That's
Right.
an exchange. That's peer-to-peer. There's no house. There's the horse racing association gets a takeout, a percentage as an administrative fee. Otherwise, it's peer-to-peer. And one of the biggest mischaracterizations and misnomers that Kalshi and others in their space have advanced is that the fact that it's an exchange means that it's a distinction with a difference, when sports gambling laws have long recognized that peer-to-peer and exchanges are in fact a form of gambling.
Right, right. Well, listen, Alex Kane has been on the sidelines for a long time as, that little engine who could, except he couldn't. So he had no choice but to go into prediction market. He's been on the sidelines anyhow as a regulated company cheering on FanDuel, excuse me, cheering on prediction market and stuff like that. So it was
Yeah,
obvious where he was going to go.
listen, he was the first one to kind of
Yeah.
hype these exchanges and prediction markets, but inexplicably, he got the late start in the CFTC. He was
Yeah,
talking about this stuff in 2017.
everybody noticed. Everybody noticed he was last to the game, yet
Yeah.
first one there, yet last to
And
really
first one to
pop.
speak at conferences. I
Yeah,
think he's mastered that. But the
yeah,
bottom line is, he was one of I wouldn't call it a pioneer, but he was really the first to raise this prospect. And he did this, I think, in 2017 to 2018, long before Kalshi ever registered as a DCM.
right.
And with the benefit of 2020 hindsight, if he could go back in time he would have been Kalshi today. He would have been Kalshi and Polymarket combined. And I'm not saying he can't compete,
He's
but
going to
he's
be one of
now
those
entering a
guys. Yeah, I sold my Apple stock for a cup of coffee because, I needed it. And now is worth a
no,
bazillion
no,
dollars.
no, a better example, Walter White sold his one-third interest in Gray Matters.
Well,
If
there
you
you
watch Breaking Bad, that was
go.
probably one of the worst trade stock trades of all time. So
Nice.
along those lines.
Daniel, that's the end of our time. Thank you so much. It's such an illuminating conversation. It's so much fun to talk about this stuff with you. You really love to get into the dirt with me, and that is real fun.
Yeah.
We look
No, but
forward to having you in San Diego.
thank
We'll
you.
also have this conversation. Everybody, I highly recommend you follow Daniel on Twitter. Oh, excuse me, X. What's your handle, Daniel?
Wallach Legal on Twitter, and all of my insights start on X. So if you follow me on
Yeah,
Wallach Legal, you'll get the latest developments as soon as I post them, which is pretty much every day.
yeah. And listen, thanks for all the great questions. I apologize we couldn't get to everyone. They were really great. So, Daniel, thank you so much. We will be back. Jason will be back next week. Okay. Thanks a lot, everyone. See you next week.
Thank
Bye
you very
bye.
much, everyone, for staying on and watching this. And Victor, thank you as always. It was just a great hour. I had such a fun time. It's always a pleasure. Last 2 months have just been a blast, and I look forward to San Diego. Thank you for
Oh,
extending the invitation. It'd be my honor to be part of the conference.
this is a good one. We'll get a lot of press on it. Trust me. Bye.